couple of quick things before we go ahead and get started tonight. Um, Again, I'll keep saying this. We're on Rumble, and I really, we do get a lot of people viewing us on Rumble, and I really appreciate that. We actually get, exponential amount more people watching us than actually show up. I'll have to say this, so, those that are watching us, it's good to come and show up because you'll start meeting people that you don't know, and that gives you an opportunity to talk to people and actually broaden your own experience. So I'd encourage people to come and do that. We do broadcast and we do record, and we do appreciate everybody's support on that. The one thing I'd like to ask, though, if you do view us on Rumble, and we're even on YouTube too, please follow us, subscribe to us, and like us. Put those little like things, because that's what helps the algorithms and stuff work to make things happen. Also, just a reminder that 250 years ago, the Revolutionary War was well underway, and we're actually, the country's actually celebrating this whole year what they call the America 250 Commission on that, and it's a celebration throughout the year of our independence, and this next July 4th will be the 250th anniversary of that, and so what we're doing here, Stand Up for Idaho is actually working with KID 106.3, and we're actually doing what's called we call the Historical Minute. We actually put a little advertisement on the radio there, and then every Thursday at 5 p.m. we have a historical discussion, and it takes about 8 to 10 minutes and whatnot. And we have some ladies from Stand Up for Idaho on the Jolynn Thomas Show talking about what happened 250 years ago. So we encourage everybody to tune into that. And also on that, you'll see back here in the back, we have a card flag. That's a wooden card flag. It was specially ordered by us and commissioned by us. It's a raffle. It's to help Stand Up for Idaho raise a little bit of money, but it's a fabulous piece of art. If you happen to take a look at it, it's an outstanding piece of work, like I said, and it is to celebrate the 250th anniversary. So if you're interested, we'll sell you a raffle ticket. It's $20 a ticket, and we're going to sell them until next July 4th, and then we'll go ahead and draw the winner that way and award that there. So if you're interested, please buy a raffle or 10 or so, because that would be helpful. Okay, we're in the election season, obviously, especially right now for the local elections. And and tonight even there's, another organization, Idaho Falls City Club, is having a forum, with a candidate forum with some of the people that are running for city council. That's why you were probably a little sparse here tonight. But the one thing I want to be able to say is, it's important that we all understand who the candidates are, why they're running, and who do we really support? Because at the end of the day, they're the ones that get elected are going to have an impact on your life. And I think it's very important for you to go in and find out who those candidates are and make an intelligent, vote. And obviously on that, be sure to go vote. But one thing, too, I'd like to make is if there's a candidate that you do support, and you already know that, on one of these forums, go to that forum and support them. Show them that they have support, because it is, as I say, it's a bit disheartening when you have several candidates in the room or one not talking, and one of them has a lot more supporters than somebody else, because it's really disheartening for the individuals that only have a few compared to the ones that have a room full, if you will. So go out and support. It does make a difference. It really does, and so support your candidates. And on that, next Wednesday, I'm just going to follow up again. Tomorrow night with the City Club, they're having, I think, the mayoral candidates there, and I think it's at the Compass Academy on Garfield. I don't know exactly I don't know what time it is. I think it's about 7:00 or something like that. You can go to IF City Club, I think it is, and find out for exactly the time and that. But I would encourage people to go to that. Next week, we're actually, Stand Up for Idaho is going to have a continuation of our candidate forums, and we're going to have candidates from for the city, Idaho City Council will be seats 4, 6, and then there were 2 candidates for seat 2 that could not make it last week, and they're going to come also next week. So, it'll be interesting to come and see what they have to say. Now, there's one thing that I'll have to say. We have a lot of candidate forums, and people are doing that, but there's one thing that stands out for Stand Up for Idaho. In the City Club and all that, they will have, and they've already said it, they have prepared questions that they're giving it to anybody. We don't have prepared questions. When we have our forums, there's going to be a microphone up here in front, and you get to come and ask your question. And I'll say this, that makes a lot of candidates uncomfortable. And if that makes a candidate uncomfortable to listen to your question and answer your question, I would have questions about that candidate, because they are asking you to vote for them to represent you. And in that case, they should be able to listen to your questions and be able to answer it. So if a candidate doesn't like that, I would just think twice about voting for that person. So anyway, that's my 2 bits on that. Another couple of things going on, and I was just thinking about this. We actually have quite a few things coming up over the next few weeks. And if I can get my phone to cooperate. How many of you have heard about that a few weeks ago, 250 legislators, 50 from each state, 5 from all 50 states, went on an all-expense-paid trip to Israel. And they went to Israel to be wined and dined and look to an event over there, and that event was called 50 States, One Israel. And Barbara Ehart, a local representative, was one of those representatives that went. And I asked her if she would come and tell us what was this thing all about. Personally, I don't like, we are the United States of America. We are not Israel. We are not Great Britain. We are not Argentina. We are the United States. We are our own sovereign country, if you will. And to have something like 50 states, one Israel, just bothers me. Admittedly, I don't know what happened, what was said and all that, but that's just my 2 bits there. Okay, so I would encourage us, and that will be October 29th. So come and listen to Barbara, and again, ask her the questions. What's going on with that? The following week, November 5th, we're going to have Reed Christensen come, and he was actually January 6th prisoner. He went to Washington and all that, and he's going to come and tell his story. Okay, we've all heard things about it, and so Reed's going to actually come, and I met Reed this summer, actually, during our Constitution camp for kids, and he mentioned that, and we asked him if he'd consider coming and talking, and he absolutely would. So that'll be the 5th. And then actually we have a flyer back here, and on November 12th, we're going to have a gentleman, Ben Geeson. He's actually in the audience right here, right now, and he's going to talk to us about the Federal Reserve and the national debt, and tell us a few things that we probably don't know, but we all really should know. And it will be very interesting. So again, like I say, and you can look at all these things on our calendar on our website. So I encourage you to do that. But again, what I'm saying is that we have a lot of things coming up. We do appreciate your support, but there's some good things coming. Now for tonight, though, we have a couple of gentlemen that we've actually seen before, and they came back, I think it was in August 6th, and we had some technical difficulties and actually couldn't do it. We have public defenders Jason Gustaves and Jordon Crane are coming to talk about what the role of public defender is. Now, the story behind that is we had the prosecuting attorney, Randy Neal, come and talk about budgets and things like that, and he said some things about public defenders and da-da-da and all that, and so these guys wanted their chance to say things, and so, hey, absolutely. So with that, let's give these guys a big hand, and just so everybody knows who they are, Jason, stand up, please, so we know. This is Jason, and then Jordon. That's Jordon, so everybody knows. I'm going to go ahead and turn it over to them, and it's all yours, folks. Thank you so much. Go for it.
All right. All right. Thanks, Doug. I appreciate that. I am Jason Gustaves. I'm the managing attorney for the Bonneville office of the Idaho State Public Defender.
Hello. My name is Jordon Crane. I am the district public defender for our judicial district in the 7th Judicial District here in eastern Idaho. So my job is essentially to help coordinate public defense in the 10 counties that make up our district, and I work along with Jason as his office is here in our district.
So, as Doug mentioned, there was a presentation by Randy Neal, the prosecuting attorney, back in August, where he discussed, the issues and the challenges that the prosecuting attorney's office has had, and there were a lot of questions about public defenders at that forum. And so Stand Up for Idaho invited us to come do a presentation on behalf of the public defenders to explain to the public what it is that the public defenders do. And this is not a political presentation. I appreciate Doug's discussion about coming out and to support your representatives and to vote. And we're not here advocating for any of that. We're here just to present information about the history of public defense, the necessity of why we exist, and the transition that has happened in the past year from county system to the state system. So a year ago, starting October 1st, the state public defender became a state agency after a change in the law. Prior to that, there was 44 counties, each individually had public defender offices. Now, some counties would have what was called a institutional office, which hired public defenders, attorneys, and they were employees of the county. Other counties would do it by contract. Currently in the 7th Judicial District, we have 2 institutional offices, one of which is in Bonneville County and one of which is in Jefferson County. The other 8 counties are run with contract attorneys who are private attorneys who work for a set rate. And those counties are specifically managed by Mr. Crane with his processes. I put up here on the board that the definition and purpose that has been set forth by the State Public Defender's Office is that we will provide holistic legal representation meeting the highest ethical and professional standards to protect the rights of people who cannot afford to retain counsel. And that is important because when you are looking at the power of the state to prosecute somebody, they have what appears to be infinite resources. Prosecutors have 3 levels of law enforcement typically. They have state police that investigate crimes. They'll have county sheriffs that will investigate crimes, and they will have city police that investigate. There are even, I believe Rexburg has some campus police that sometimes will help assist to investigate. When a person is indigent, which means they fall under the poverty guidelines under the law, they can't afford to resist or defend themselves with such a power against them. So that's when the ability to have a person that represents you is appointed. Now, under English common law, way back before we were in a nation, you didn't necessarily have the right to an attorney. People would get convicted without having an attorney there. There was very little rules of court. A judge would pronounce sentence, and a person could be thrown in jail, in prison, or have their lives taken. Under our Bill of Rights, which is in our United States Constitution, we have the Constitution, and then the Bill of Rights was passed a couple of years later in 1791, which established certain other rights. First of which is, the First Amendment right to free speech and right to assembly. Second Amendment right to bear arms. Fourth Amendment has the right against search and seizure while being safe in your homes or without arrest without a warrant or probable cause. And the Fifth Amendment right to due process, the right to remain silent, and the Sixth Amendment right to trial, and the right to have counsel. Now, those were set forth in 1791, and you know, it sounds a little bit like a history lesson, like government high school, but a lot of times people didn't necessarily pay attention, because when you're a senior in high school, you don't really care about all that. You want to get out of high school. Now, we provide representation for people who can't afford it, so there are indigency standards. Having a defense attorney ensures that people are, if there are convictions, that those are supported by facts and law, and it helps to prevent wrongful convictions. And we have a balanced system, because in order to ensure that people's rights are preserved, not just the rights of the defendants to a proper trial, but also the rights of the community to be protected against crimes, against persons that would harm persons or their property rights or their financial rights. So the system has to be balanced in order for everything to work properly. Now, yes. Certainly.
Okay, well, questions, we need to use the microphone if we can, so people at home can hear us.
Yeah, when you're talking about indigency, if I said that right, standards. So for instance, if you're retired and you've got retirement, saved up for the next 30 years before you die, so that what happens is you have to use that up and be bankrupt before you can get help from the district attorney?
Well, so there is an application that has to be filled out. That is a state Supreme Court document. Let me clarify too. We represent people that are charged at the state level or the county level for crimes, which is under Idaho state law. If there are federal crimes, that belongs in the federal courts, and that's not what we do. So I'll clarify. So the form that you would fill out asks you to list out all your assets, and that would be money you have in the bank. If you have access to funds that could be liquidated, if you have assets in interest in a house that has equity, or cars that have equity, things like that. So the judges will take a look at that. If you have, say, Social Security, and you have a big lump sum, but you only get an amount per month, they only consider the amount you get per month. And the indigency standards in Idaho are based upon the federal poverty guidelines times 175%. It's not very high, but it can be if there's a family with multiple dependents. So you don't necessarily have to exhaust all your remedies, or your money. Sometimes with people that are charged with financial crimes, sometimes if their funds are locked up and they don't have access to those funds, they can be granted a defense attorney because they don't have access to those funds. There was a question last time about who ensures that those people remain indigent, and that's not what our job is to do as public defenders. They fill out a document that they swear under oath, and they provide that to the court, and the court can inquire. If there's an issue of them improperly disclosing funds, then that's an issue for another avenue, not ours. Our job is to represent our people.
And also, so ultimately, it comes down to the judge can make that decision. So the poverty guidelines kind of kick in the analysis. Okay, it looks like you might be someone who qualifies. And then the judge can take into account a lot of different factors. Maybe you have that retirement, but you're going to need that retirement for the next 30 years. And do we think you should exhaust it? What exactly is the level of the assets you have? Another thing that they'll look at is, what are you charged with? If it's a relatively minor offense, disturbing the peace because you lit off some fireworks and your neighbor got you cited for disturbing the peace, that's one thing. If it's a murder case, that's another. So the court can kind of use that sliding scale to exercise its discretion. Once we're appointed, we kind of just say, okay, we're appointed, and we're gonna take you on as a client and represent you.
So under our Constitution, you had the right to an attorney, but it didn't say how one was to be presented. Now, under our, I covered what the basic constitutional rights were. Now, under the 14th Amendment, that incorporated the Bill of Rights to the states, because the federal Bill of Rights wasn't necessarily incorporated unless it said so. Now, so the 14th Amendment said, yes, the states must follow that. But Idaho, in its constitution in 1890, did incorporate that you had the right to defense of counsel. Now, the Fifth Amendment, says, which was passed in 1791, says, the highlighted portion, nor deprived of life, liberty, or property without due process of law. So that says that the government has to go through processes to ensure that your rights are preserved. The Sixth Amendment has the right to assistance of counsel for your defense, but that doesn't say that one has to be provided for you. It just says you have the right to have one. The 14th Amendment, incorporated that to the states and said the states must follow those as well, and that was in 1868. Idaho was a territory up until 1890, and in Idaho's constitution, in Article 1, which provides many of the same Bill of Rights and rights as the federal Bill of Rights, says specifically to appear in person and with counsel. So that was, assumed that you had the right to an attorney in 1890, but it didn't say that you had the right to have one appointed for you if you couldn't afford one. Now, in 1932, in Alabama, there were some gentlemen charged with murder, and they were facing the death penalty, and they went to trial without an attorney, and they were convicted. And the U.S. Supreme Court said the fact that they were convicted and sentenced to death without an attorney, they should have had an attorney appointed. However, this was specifically read only to apply in death penalty cases. It wasn't, to other cases. But then later, in a case called Gideon v. Wainwright, in 1963, they said that the ideal of that they referenced Powell versus Alabama, that the poor man charged with the crime has to face his accusers without a lawyer to assist him. That cannot be. That's not what the American dream is. It's not what we intended when the Constitution was drafted. They made a movie about that with Henry Fonda. It's called Gideon's Trumpet. And he played the old fellow who basically just was robbing cigarette machines for beer money, and he asked for an attorney over and over. He said, I can't afford one, so they didn't give one. And finally, after his conviction, the United States Supreme Court said even a poor man should have an attorney, and that's where that came from. But
and so Gideon actually hand wrote his pleadings to the U.S. Supreme Court, saying, I repeatedly asked for an attorney. I'm not trained in the law. It wasn't fair. I should have had an attorney appointed. And so the U.S. Supreme Court got those handwritten pleadings by this simple man and ended up granting him that relief. He went back. They remanded the case back to the state court, and he was found not guilty, that he hadn't actually committed the crime that he was convicted of.
And so at that point, it codified that to the states. Now, the issue then became how do the states deal with paying for that? And so then it was the state of Idaho, at least, did a county-based system, and each county was responsible for providing what they call indigent defense. And so some counties did it by contract. I think they probably all originally did it by contract to begin with, and then over time developed institutional offices, which were professional attorneys. And we get called a lot of names, not real attorneys, public pretenders. But I guarantee you, we all went to the same law schools as the private attorneys. We have to take the same bar exam that they take. And that's all that we basically do is criminal law, with some exceptions. Generally, that's all we focus on. Because there is a statute that applies that says what we are mandated to do and what we do not do. So the purpose of the state public defender system there is to ensure that people are granted a consistent and adequate level of representation around the state. There are standards that attorneys have to, that defense attorneys have to adhere to. There's a set of caseload standards that they have to ensure that attorneys are not overworked and that they have a proper amount of time to attribute to their cases. However, over time, county public defenders, and I'm not naming any particular, but they are usually typically underfunded. They did not like having to provide attorneys for people who committed crimes, and if they didn't have to provide them, they likely didn't. But we certainly didn't have the level of assets that prosecutors had and law enforcement had. So public defender offices were typically understaffed with attorneys and with assistants. They were underpaid. They didn't have access. They don't have access to investigators typically or experts. They had to request funds from what they call the district court fund for that, and you have to submit a motion and explain to the court why you needed this money to get an expert on behalf of your client. Say there's a murder and you want to have the toxicology reports checked out, or have your own medical examiner look at something, or ballistics, fingerprints, handwriting experts, those kind of things. And all of those would come at the expenses of the counties. And some counties have more money than others. You look at Clark County, it has only a couple thousand people I think live there in Clark County, but they also only have a couple hundred crimes a year. But a serious felony in Clark County is kind of a big deal compared to the driving offenses and hunting offenses. Whereas you have an Ada County where you have 50% of the population of Idaho lives over in that area. They have a lot more funding. They have a lot more attorneys and experts and things to rely on. So the different counties struggled with different levels of representation and funding. There was a lawsuit filed in 2015 called the Tucker v. State of Idaho, which was a lawsuit brought by the ACLU on behalf of people that were accused of crimes, convicted, and there was numerous claims that they had about the fact that their public defenders didn't have enough time to do the job, didn't care about doing their job, didn't argue for their release. There's myriad complaints. It was granted class action lawsuit by the Idaho Supreme Court, and so it proceeded, and so then that began a investigation by the legislature into how do we properly do that. They created a public defense commission in 2014, and so they began to look at funding, training, and adequacy of public defense on an equal basis around the 44 counties. So over time, as the lawsuit progressed and the funding changed, in Bonneville County, we requested funding, and we were granted more funding. We hired more defense attorneys. The wages increased a little bit, which helped to draw more people in, because quite frankly, public service in Idaho is typically underpaid. And that's whether you're a prosecutor or a defense attorney, whether you work for farms, Department of Transportation, a lot of those, it just doesn't pay as well as some of our other states like California, Washington, New York. So in about a little over 2 years ago, the statute was passed that created the State Public Defender Office. And Eric Fredrickson was chosen to be the executive director of the State Public Defender's Office in 2023, and he was given about a year to create an entire agency under the state. And that would be like creating a Department of Transportation or creating a Department of Health and Welfare. They created the Department of the State Public Defender's Office. And the State Public Defender's Office started October 1st of 2024. Now, over time, we have opened up more institutional offices. I think there's close to 20 institutional offices now in the state, but that means there are approximately 24 counties that are still run by contract attorneys. And here, like I said earlier, we have Bonneville County has 14 attorneys, we have 10 assistants, and we have 1 investigator. Now, we compare 1 investigator versus 3 levels of law enforcement. Yes, Doug? Oh, I thought you. In Jefferson County, we have 1 attorney and 1 legal assistant. The other 8 counties have attorneys who have signed up as contractors, and when the cases come in, they have to call around and say, who has the time, who wants the case. Now, the way a case works is our office can only handle or only take one defendant who's charged with a crime. If there are multiple people, say, arrested at a single time that are witnesses against each other, or could be pointing the finger at somebody else that did it, then the conflict cases. And the contractors who do the work in the other counties also contract to be conflict attorneys in this county. So there's still, there are more than the 14, public defenders here. There are probably close to 20 other attorneys that do contract work. Now, some of the work that defense attorneys do, we do counseling for them as to how they can defend their case, whether they have a good defense, whether they have what's called mitigation, which means it's not a defense that a true defense is, a true defense is didn't do it, wasn't my drugs, one arm killed my wife, whereas mitigation is I did it but, or I'm guilty but I have mental health issues, I have a substance problem, whatever, I was under duress, those kind of things. But we also can help people with substance abuse counseling. We can help them with housing. I have this screen. So this kind of gives people an idea of who we represent in the public defender's office. We have people that are charged with crimes, but we also have people who suffer from substance abuse issues, from mental health abuse or mental health issues, people that have food insecurity, that have housing insecurity, domestic violence in their history, that have been victimized by violence or by sexual assault, or any mix of any of those. And oftentimes when we get clients that might be on their worst day of their life, they don't have anybody else to call. And so that's what we're here for, is to help those people in those situations. The American Bar Association sets forth, which is a association for attorneys nationwide, and it sets forth 10 what we call goals for the public defense, or what a public defender should do. And it sets these out that the independence should be that a defense attorney system should be independent from the other 3 branches of government, because you've got the legislative branch that passes the laws. You've got the court system that adjudicates those laws and sets forth the rules of court, with court procedures and with rules of evidence. And then you've got the executive branch, which executes the laws, which prosecutes those laws. Public defenders are essentially kind of outside of those 3 branches. We have the Constitution. We fight those with the Constitution to ensure that justice is done, and it is done properly within the laws, the rules, and the Constitution.
And so along that independence, we represent the individual. We're tasked with representing the individual against the weight of the government. And so the principle of independence means we can't be influenced by what a judge might think when we make our defense or when we argue on behalf of our client. We can't be afraid to say, if I make that argument, our funding might get cut because this party's in power or that party's in power. And so we're tasked with being independent from the judiciary so that we can represent our clients to the fullest extent and make sure their rights are protected. At the same time, we need to be politically independent so that representation doesn't sway with who's in charge. So that's part of we got to just focus on that individual. Sure.
So I think one of the criticisms of the county system was oftentimes the district attorney was underneath like the county prosecutor. And so there are allegations or potential conflicts there. So I just question on, do you think the new state system is more independent? Do you feel better about that?
I think that on the local level, there's probably a little bit more independence. And I think what you're talking about is a little bit, it's more of a perception that you see, because we were county employees and the county prosecutor is prosecuting it. So we hear from our clients, well, you work for the same person that's trying to prosecute. Your paycheck comes from the same place. And that's fair, right? And right now, our check comes from the state, and the state versus defendant. And so that's fair, and that's why we put these principles in place. They're codified. Jason is the managing attorney, myself is the district public defender, Mr. Fredrickson is the state public defender. We're tasked with making sure our attorneys understand that and are ethical and protect the individual. Attorneys, just as a general matter, have their own ethical rules. We have our own ethical rules that we have to follow, and those kind of steer us from kind of the conflict that you're talking about. But it is a kind of an odd perception, right, that we're kind of working for the same team. And so our job is just to stay vigilant and to make sure that we represent our clients to the best of our abilities. There's some of us that are maybe more in the management level that have to deal with. We're not politically isolated. We try to be independent, but you can never be isolated, right? We have to get along with the judiciary. We have to work with judges. We have to work with the politicians, or who are deciding whether we get a budget or don't, or what that budget should be. And so we do have to cooperate with politicians. And so it's not like we're isolated, but when really what we want to do is we want to have the management have to deal with that, and then when you have the attorneys on the ground that are fighting those battles every day to say, you don't worry about it, you do your job, we're going to handle it. And so the state allows us to kind of move that up one level above kind of the attorneys that are on the ground level, and so I think it does kind of foster more independence than that local system. It's a good question. Thank you.
The next one is just to ensure that funding and the structure and the oversight is separate from any other agency, because before, the counties controlled the budget. The counties controlled the salaries, and also they had the district court fund, and the counties would have to set aside from their tax budget a district court fund to have these monies set aside. And now that's not an issue. Now that belongs to the state agency. The public defenders have a state budget that they have to allocate. However, that budget is approved it's requested, and then it's approved by the legislature and signed by the governor. So there is still a little bit of thumbs in the political realm of that type of oversight and control. But also that makes sure that they're not just out there spending money willy-nilly too. There's a level of responsibility. Another thing is the control of workloads. The American Bar Association has a set of workloads that is aspirational. It's always been aspirational that there's a certain number of felony cases that an attorney should have no more than per year, or misdemeanor cases that they should not exceed per year. That's not a hard and fast rule. That has never really been attainable at the county levels, at least where we're at. Ada County was funded a lot better, and Ada County was under those numbers. But that was a 20-year process for their public defender office to get that sort of buy-in with the county commissioners and things to ensure that they had a workable funding system. And it has gotten better over here. We have data collection and transparency. They have a digital system that tracks our cases, that we put information in, and has a timekeeping function so that they can start then evaluating, using data, the amount of time that's put in, the amount of money that's put in, what the workload standards are to ensure that there is accountability, and to be able to say, are those workloads achievable or not, and is the system doing what it's intended to do. The eligibility and fees for public defense, that's already been covered. There's a statute that's on hand that the Idaho has set forth. Public defender fees are assessed upon conviction. There is an amount that is ordered by the judges as a fee paid back into a fund, that when it's paid in, it goes through the colors of green go back eventually to that. But it's to ensure that while public defenders are not as expensive as private attorneys, that the people have accountability if they are convicted, that they pay something. However, if there is a case and they're found not guilty, there's no fee, which I think is appropriate, because if you're wrongfully charged and the state doesn't convict you, you shouldn't be in order to pay anything. You wouldn't have that if you have a private attorney and you've paid them thousands of dollars, and then you're not guilty at the end. That attorney's not going to give you the money back. He's going to say, I did a great job for you. Early and confidential access to counsel. So one of the things that we are obligated to do is at least here in Bonneville County, they have initial appearances every day at 1:30, every workday, where people who have been charged with crimes, they either have to appear in court, or if they are in custody, they have a right to be arraigned by a judge within 24 hours. And we have a public defender there at every initial appearance to ensure that we can address if the people are eligible for bond, to ensure that if they need a public defender, that theirs are applied for, and that one is appointed if they qualify. And then we can begin the process of representing them as quickly as possible. Experience, training, and supervision. So one of the things is to ensure that we have trained and qualified people that are able to do trials, that have the trial skills, that have the ability to read the law, to review the facts and the evidence and compare to the law, and apprise a person who's been charged of their options and their likelihood, and whether they have trial or whether they have a resolution, or what that is. Yes, ma'am.
So I have a grandson that wants to be a prosecuting attorney. I can't understand that, because it seems to me you have to defend people that you know are guilty, that you can see that they're scum of the earth type of people, and some of them, they get off on riders, and it seems like it's a kind of unfulfilling. I don't know how you guys feel about it, but right now there's a big hue and cry from the public about all the riders that are being put out, and so trying to figure out. So back to experience. I got so many thoughts. Experience. So my grandson graduates from college, got his degree to be a lawyer. What kind of experience does he need to become a public defender? We'll start with that. Then I want to talk about writers. Thank you.
So in order to be a public defender, you need to be licensed in Idaho to be an attorney, right? And that would qualify you, because they'll kick you out the door and say, it's time to fly. You're an attorney. You're licensed. You're accountable for everything you learned, and you're accountable for keeping your license. Now, in a practical sense, we wouldn't just throw you to the wolves and say, okay, it's your first day, here's a murder case, go knock yourself out. You're going to usually start on more simple, straightforward cases in misdemeanor court and kind of cut your teeth on that, and then you build that experience. And that's kind of the beauty of having the institutional offices, is we can kind of mentor the younger attorneys. And so that's kind of the experience that comes along. That we talk about. And so we don't want a situation where we're having really green or inexperienced attorneys take really heavy cases. And that's kind of what the experience says. You're going to match the attorney with their experience. And so hopefully it would be through just learning as you go, really, and then having a good mentor. I would encourage, is your grandson, you said? One of the best things he can do as a young lawyer is find good mentors. And they'll really... Lawyers love to pass it, pay it forward. And so I would encourage you to tell him to find a good mentor and that'll really pay dividends in the future for them. And now to the question that we were waiting for, right? How can you represent someone you know is guilty, right? That's the question we get at Thanksgiving dinner. That's the question that my grandparents or, the in-laws will ask. And the question is probably answered differently for everybody else, so I can only answer it mainly for myself. But it really boils down to a love for the Constitution and a love for the system that this country has. We have the best system in the world. I haven't lived under any others, but I've seen some things, and so I'm pretty confident to say that. And if public defenders don't protect the people that are guilty, who will protect the people that are innocent? So you'll have someone who is charged, and if we just went, Jason, he's guilty, pass him along. The government says he's guilty, right? This elected politician who's a prosecutor, who wants to get elected, decided he's guilty. They tell me, this law enforcement officer tells me he's guilty. He doesn't need protection. She doesn't need protection. What happens when that person comes along, and it's the same prosecutor, the same law enforcement officers that are saying they're guilty, and we don't protect them? And so what I do is I say, I'm going to do my best to do my job as my role to protect the individual against the power of the government. And when our system's set up and we have good, strong, experienced, well-funded public defenders, and we have strong, ethical, properly funded prosecutors, and strong, ethically, properly funded law enforcement officers, then you get the right result. We stand up and we say, you better prove it. I know you said they did it, but you better prove it. I know you searched their house, you better prove why you went into their house, right? You want to take my client's life. You want to take their freedom. You want to take their money. You want to ruin their reputation. You're going to have to go through me and prove it. And if you do that, the system has worked, right? And so it's when things get kind of out of whack, where maybe one of the stakeholders has a larger pool of resources or more influence, and things start to get out of whack, right? So it's a balance we try to reach. And so I just try to keep my perspective. I'm a member of this community. I have family. I have kids here, a wife here, grandkids. And so I want my community to be safe just like you guys do. So it's not about getting bad guys off or being pro-crime. It's just being about pro-Constitution and saying, I have a role to play, and I'm going to play it to the best of my ability. And hopefully all the other players play their role appropriately, and we get the good decision out. One more thing, and then I'll turn it over. But many of you may have heard about Christopher Tapp. It was actually the Bonneville County Public Defender's Office and John Thomas, who was the deputy attorney when we were a county, that did a lot of work to get Chris exonerated. It was a public defender that believed he was innocent. Chris confessed. And so in today's day and age, that crime with a confession, just imagine what social media would look like, and imagine, why don't we just string him up? Why is he getting a trial? Why does he get a free attorney? But it turns out the kid was innocent, and we don't want that to happen. And so we just stand up, like I say, and have faith that everything else is going to work around us. So that's kind of why I do it.
I don't know if now's the right time or not, but I ask a hard question the other way, maybe coming from a different direction. Have you seen cases where prosecutors are evidently or blatantly prosecuting maybe because they want political brownie points?
Okay. I can't say that I've necessarily seen a prosecutor in our local jurisdictions seek somebody out and say, I'm going to get that guy because he didn't vote for me, or but I have seen prosecutors maybe go too hard, overcharge, push too hard, because of maybe what they think the public perception would be. Being a prosecutor is a hard job because they have to try and do what's right in a broad sense for the community, for the defendant, for the victims, right? So they do have a very hard job. And so sometimes I think what we see is when prosecutors get a little overwhelmed with what do we do, it's hard to balance all that. I have seen prosecutors probably push too hard on cases they shouldn't. It's mainly overcharging that I see. So there's maybe a couple. I'm not at liberty to specifically say because of confidentiality to my clients, but there's probably a few where I would sit back and say, what in the were you thinking when you prosecuted that? But fortunately, I think for the most part, they try to do their best. Now, I think nationally we kind of see how that can be abused depending on who's in power and who can appoint the prosecutor and fire the prosecutor. And so it does get a little scary when you see those things kind of happen, but I think Southeast Idaho is a good place to live, and I think for the most part, things are okay.
So looking at principle 4 with the data collection and transparency, is that like an internal thing for your guys only, or is there some place that we can see like how different plea deals have like panned out, if there's recidivism, if they're assigned to a specialty court that they, graduated in a normal, like a set of time, or they're actually using like the restorative justice piece like in a way that's actually helping them and helping the community?
So my understanding so far is that's not available at this time. We just, as of September 30th, finished the first year of being a state agency. That includes the first year of them collecting that data with that digital format. We brought in input cases that were already ongoing as of October 1st that were already in there. And now we have roughly 1 year's worth of data, of what I would say probably clean data. The system that we're using is intended to be able to produce that type of information. We do not have that at a local avenue. I have reports that I can run to see what my attorneys are doing, how many cases I have that as a local deal. At the higher level, the executive director and those people will have access to that data so they can make those larger budgetary type of decisions and have those discussions with legislators. There is so the state of Idaho, the court system, I want to say it's courtdata.idaho.gov, I think, this Idaho Supreme Court does case tracking. And that tracks cases around the state, and you can drill down to convictions and numbers of cases with the different counties or the districts, and you can go by the types of charges, and you can go by the year. I'm not sure exactly how many years they've been tracking that, but you can go look and see over time. You can go and look. Have we seen an increase in in crimes over time? And since you asked about like statistics and things, one of the statements was that our crime has jumped so much in the past 5 years. Now, in the year 2020, the crime rate did increase around the state, and particularly in Bonneville County, to a certain level. But since 2020 through 2024, the numbers are available on that, the cases have stayed relatively similar. So while it may seem in the news that there is more rapes or murders or drug charges or whatever, those are pretty consistent for the past 4 years since that 2020. So those, and Mr. Neal had said that during his tenure there was a jump in cases, but that's not accurate because he's been here since 2022. He's been in here 3 years now. He came in the middle of that time frame. It's stayed pretty consistent.
Looking at the other end of it with like the prosecuting attorneys and the judges that are elected, you guys are hired. So like, is there anything to track their like performance so that we can take that into account and be informed voters to hold them accountable and know how to not flip a coin to see who we want to retain or.
No, and there's a reason for that. Now, so one, when a case is sent to the public defender's office, they're assigned by a system that we have in our office, and it doesn't have anything to do with who the person is or who the attorney is. We just have assigned by the judge, and the person therefore doesn't have a choice of who their public defender is, and the public defender doesn't have a choice of who his client is. So they have each other in a relationship at that point, and that technically precludes any favorability or anything like that. But also, while the prosecutor can have a prosecutorial philosophy, like we're going to be stiff on violent crime, or we're going to be stiff on murders and rapes, as public defenders, we don't have that. We don't have a philosophy like that. What we have is we get the case that we get, and we get the facts that we get, and then we work to work with and investigate those facts and defend that case. So we don't have the ability really to culture the case the way we would want it. So having statistics that would say this attorney gets a lot of convictions as a public defender, he must be doing a terrible job. Well, maybe he's the guy that does a lot of the most serious sex offense cases, and those are hard to defend. They're hard to prosecute and they're hard to defend. So you can't necessarily evaluate that.
I think were you asking about whether there's a way to see if you could see what maybe the prosecutors are prosecuting, dealing down, winning at trial, losing at trial, what the judges are doing. I'm not sure what type of database collects that data, to be honest. Off the top of my head, I don't know. It would be a real pain in the butt to have to sit and watch court all day, every day, to figure that out by yourself, right? Because you got other things to do. And so I really don't know if there's...
Every case is different.
So
every case has different sets of facts. And so you can end up with two similar people charged with a similar crime that have radically different results because of the individual facts of each case and which prosecutor they deal with, which defense attorney they have, perhaps what judge they have. So there's too many variables for that really to be singled out. More questions is fine. The next one is vertical representation. So the intention, now while we have an attorney at that initial appearance, that attorney won't necessarily be that person there, because quite frankly, I can't have all 14 of my attorneys sitting in court every day waiting for the new cases. It's not like throwing business cards at people. But what we do is once they're appointed, the goal is that attorney works with that client for the entirety of that case. We don't, do part of the case and hand it off to another attorney and then hand it off to another attorney at some point, barring anything really extraordinary. The goal is that attorney gets to know that client, and so that they can work towards having a relationship, so they can have a level of trust and with each other, to know that the attorney's doing the job for the client, that the client is getting his or her needs met to wherever that's going to end up. It sets out effective components of effective representation. I'm not going to go into that. And then the public defense system as legal system partners. And that we've talked about that, both Mr. Crane and I have talked about how you have to have a functioning system where all the gears work and they work equally. Because otherwise things that get out of whack are unfair one way or the other. So this is, what does the public defender's office actually do? So under Idaho Code Title 18, that's what's called crimes and punishments. And that is the majority of crimes that are against persons or property or things. It includes violent crimes. It includes thefts, crimes against persons. It has sex offenses, assaults, batteries, disturbing the peace. Those sorts of things that are at the county and state. Title 37 refers to food and drugs and things, but that there's a section under there that deals with what are legal or illegal drugs. And that's where we see a lot of our drug problems, possession of illegal substances, delivery of substances, trafficking, being under the influence in public. Title 19, criminal procedure, that's actually a set of rules that defines how the criminal laws are implemented, and things like speedy trial issues, how people can file for post-convictions if they believe they were wrongfully convicted, how they can appeal if they believe they were wrongfully convicted. That sets out, that's a whole section that sets out, modifiers to the other sections. Title 49 is actually the traffic code that deals with all aspects of like transportation. But within that, that deals with things that are considered crimes, like driving without a license, driving overweight tickets for heavy transport, things like that. That driver's license, just having a driver's license, falls under Title 49. How you license and register your car is all under that. There are various levels of crimes that we deal with. There are juvenile crimes, which is the children that are under 18 are called juveniles under the law, and they don't have crimes, they have offenses. And they face detention if they are convicted or found to have committed those offenses. Typically, though, in general, they put them on probation because the goal is to deter juveniles and rehabilitate them rather than put them in jail or detention. We also have misdemeanor crimes, which can be things as simple as traffic offenses up to DUI. There is a misdemeanor level of vehicular homicide, thefts, batteries. Felonies are obviously the more serious crimes. Those can get you prison time. It can send you to the penitentiary, whereas misdemeanors are usually punished by jail time at the local county jail level. And then capital cases are ones where the state can seek the death penalty for whatever those are. And those are typically for rape or murder. There is a new statute that just took effect this year where lewd conduct under 12 years old can get a person the death penalty. And that is currently, I think, going to be subject to litigation. We also appear at all initial appearances, so we have an attorney there every day at 1:30 to make sure that if people are in jail, they have the opportunity to argue for bail or bond so that they aren't held unnecessarily. If you think back to the days of like old Mayberry, and you have Otis the drunk, and he goes and he gets drunk, and the next day he's in front of the magistrate, and the judge lets old Otis back out, right? Well, there are times where we'll have judges that look at it and say, this is the 10th time you've been arrested for being drunk in public. I'm going to leave you in jail. And then we can argue and try to get that person released, with the information we have, and perhaps we can get them into some sort of substance abuse treatment, or maybe they don't have a house, maybe they don't have anywhere to live, and they just live on the street, so they just keep getting picked up by the police as a vagrant or drunk in public or something like that, disturbing the peace. There are treatment courts that were introduced a little over 20 years ago. I want to say 2000-ish. And a treatment court, they have different ways that they do those, but treatment courts are typically for people who have been convicted of a crime, but they have a substance abuse issue or a mental health issue that can be treated because they are a lower risk, and they can be treated in the community. And they're typically put on probation, and a term of their probation is that they have to do this treatment court. And then they have a phased program that they can be in anywhere from a year to 2 years, where that treatment program helps them with their substance abuse issues, with their mental health issues, can help them get a job, get solid housing, medication, because for some people, they've never had that as a stable issue in their life.
You have a great hairstyle. I think that's great. As a bald man, it makes me sad.
Thanks.
Okay. Can you share a little bit about the economics about the treatment court as compared to someone in jail? There are a lot of people who are like, if we're using taxpayer money, why are we just helping? Why don't we just put people in jail and just leave them there? in terms of economics, can you explain a little bit about that?
So the majority of the United States population is approximately 1 month from being homeless and bankrupt. So imagine being arrested for a crime and spending 2 months in jail. For the majority of people, that would, especially people that are of the low income that we represent, that is extremely detrimental. They lose their house, they lose their furnishings, they lose their car, their driver's license gets suspended because their insurance lapses, they lose their cell phone privileges. If they have children, their children might end up in the care of health and welfare. So that's extremely detrimental. So a treatment court can help to stabilize those people. They can help them to get into housing if they don't have it. They can help them get treatment and those sorts of things. The treatment court administrator that we had here a few years ago had told me, and this is out as of 7 or 8 years ago, that it costs approximately $14,000 to put a person through a treatment court, but it's $40,000 a year to house somebody in the prison. And so from a sheer economics, we should at least try for the people that have those issues and are a lower risk, and so they're capable of being supervised in the community. It just makes fiscal taxpayer sense. Now, there are people that are a higher risk level, that are a risk to society, a risk to themselves, a risk to injure or harm other people, and that's when the judges will say, no, they don't need a treatment court. They need something more intensive, such as a rider that the gal asked about earlier.
And so treatment courts, as Jason said, have been around for probably 30 years, 20 years in this area. They're probably one of the most studied areas of the criminal justice system. So there's been years and years and years of data and follow-ups and, seeing what this cost-benefit analysis is of putting someone through this rigorous, probation or treatment program versus just sending them to prison. And, if you send someone to prison, they might not commit crimes while they're there, or at least out here. Whether they're doing it inside or not is a different thing. But, that is one way to handle it. But as Jason said, it's going to cost you tens of thousands of dollars a year. One of the side benefits of a treatment court is if you can keep even a third of them from reoffending and stabilizing and getting that car and paying that insurance and paying their rent or paying their mortgage, all of a sudden they're contributing to the economy. They're no longer a drain. It's better for them. And so it really is a way, even going forward, to try and, save society money. And that's why treatment courts work. It took a while for me to get sold on treatment courts, if I'm honest with you. So I kind of went through the process of saying, hey, is this good? Is this good for my clients? Is it good? Do they work? Right? They don't work for everybody. Nothing really does, but they do really save money in the long run if you look at, and there's tons of studies online that you can look to. I don't have those numbers with me. And this kind of dovetails to another thing that I think the state system might help with public defense. When I started in Bonneville County as a public defender, there were six of us in the office. And my first day, I got a stack of files this big. And that wasn't just all my files. That was court on Thursday. So get up to speed and go. And you would just have to kind of process these cases. You wouldn't get a chance to know your client, to know the case, to do the job that a good lawyer wants to do, right? And so it was just this processing cases. And what the increased funding and the transition to the state has allowed us to do is take a step back and not only become better lawyers and protect the rights of our clients better in the Constitution, but it allows us to engage a little more in what we call holistic representation. And that was on one of the very first slides that Jason had that talk about what the public defenders do. Holistic representation talks about us. We'll get a client that comes to us and it's a bad day. They've been having maybe a bad life, a bad year, who knows. Substance abuse issues. They come from a history of trauma. They're caught in a cycle of in and out of jail, or, they can't hold jobs. And one of the things that a public defender has an opportunity to do is say, you know what? I'm going to take care of your criminal case. You got charged with petty theft for stealing from Walmart again. But man, we don't want you to do this anymore. What can we do to help you? And so with the increased resources that we have, we can now say, hey, I can get you into this program. And it'll help sober you up. Maybe there's voc rehab. Maybe we can get you your GED. And so we can try and add value. There's value in public defense that a lot of times the community doesn't see, other than just getting people riders or getting people acquitted or, getting plea agreements. We're trying to do work behind the scenes to change these people's lives so that they don't come back. I don't want clients. If in a perfect world, we wouldn't have public defenders and we wouldn't have clients. In a slightly imperfect world, we'd only have clients one time because they'd get it. But, it's a lot of times that it's just generational. But so that holistic kind of ties into that, the idea of treatment courts and just trying to teach people life skills and get them out of the system and so that they can contribute to society instead of being a drain,
Bonneville County has 7 treatment courts. Do we have a question?
So you mentioned earlier, and it came up again here, about public defenders being able to help people find homes. So how is that funded, and how do you do that? Do you go work through another agency, or what?
I think really we don't get to pay their rent. So really what we do is we partner with other entities in the community that can do that. Sometimes there's state funding or federal funding that might come into that, but we usually send them in the right direction. We say, hey, I can point you in the direction of services. And that's really pretty much what we would do. I think Jason's office is probably much more engaged in that than I am now because, they're a little closer to the ground level, but I think that it's just partnering with the community.
We have a lot of contacts with local treatment providers for health care, for mental health care, for substance abuse counseling and treatment. We have partnered with the Center for Hope that's over there on the corner of Anderson and Holmes, that they will help people with substance issues to try to help them with housing. There are local safe and sober houses that will have drug-free homes where people rent. And there are services like Idaho Housing. So what we do is we serve as kind of a clearinghouse of information to help guide those people. In the future, one of the goals is that we will have social workers in our office that will help those people as well. As it is right now, we have avenues and services we point them to, but we don't necessarily have those people in office that do that. That falls to the attorneys and the assistants to help with as much as we can. It is our goal, our aspirational goal, and it's essentially kind of a budgetary issue. Do we have, once we get funding to get that, because we have attorneys that fight the cases, but also we have to have the support personnel to help that. The legal assistants do that, social workers do that. We also have a lot of partners in the community. We partner with law enforcement, and I don't want people to think that means, we're not selling our clients out, but you make professional relationships with the sheriff's office, the Idaho Falls Police Department, because the jail's goal is not necessarily to house people all the time either. The jail doesn't want to be full. The jail would prefer that people are out in the community working and being productive and not breaking the law. So we work with the jail to help to get people into housing and things like that too. Every month we meet and we talk about people that are in the jail that have serious substance abuse or mental health issues, so that we can say, do they need to be evaluated, so maybe they are a person that should be in the state hospital because they shouldn't be in jail? Are they people that continue to come back because they repeatedly have mental health issues, and that's what their problem is? That it's not that they're intentionally violent, but they suffer from that issue. The treatment courts are a group of the court personnel, treatment personnel, a probation officer, either misdemeanor probation or felony probation or both, a defense attorney, and a prosecutor. And those are all the people that are the staff for a particular treatment court. We have 7 of those here in Bonneville County. And they have the capacity for between 30 and I think 60, maybe Wood Court has 80 persons that can be in each of those courts. We have juvenile drug court, we have juvenile mental health court, and then we have adult levels at misdemeanor and felony level. And those are diversionary courts that are intended to help give people structure and support so that they don't go to prison, so they get rehabilitated, so that they hopefully don't continue a life where they just continually be in trouble with the law. Because, John Stuart Mill's utilitarianism is you do the most amount of good for the most amount of people. And if you maximize everybody's individual capability, then you can make overall society better. And that's an aspirational goal. That's what we hope to do, and we don't always get there.
So are these the people that are getting riders? Because I asked about riders, because people are really upset. Everywhere I see on social media, they're so upset about all the riders that are giving out. So what you're doing there, this holistic approach, is that the people that are getting the riders?
Okay, so did the prosecutor explain the rider program when he was at the last presentation? Because I think you asked that question last time, right? Okay. So what a rider is, that's the colloquial term. It's called a retained jurisdiction. And what that means is the judge in a felony case, so not misdemeanors, in a felony case, the judge took a look at the person, and right now they are too high of a risk to themselves or to society to be in the prison, or to go to prison, just goodbye, I'm done with you. However, they have the capacity for treatment and intervention to where if they get a treatment program and they are successful and they take it to heart, they do the work, and they then are successful with the treatment that they're given the opportunity to come back and be on probation rather than being in prison. That is a diversionary tool as well, because they do go to the prison. It's not the deep cell block max, but it's they're like a boot camp sometimes, and they go do that programming, and as long as they take it to heart, then they can come back to be on probation and show the court that they can complete probation in the community. Now, there are studies that were done about happens when you mix low-risk offenders with high-risk offenders. You take a person who doesn't know much crime and you go put them in with the hardened criminals. They come out as hardened criminals because they spend years in learning about drugs and violence and things, and they harden up, and so they come out as a higher risk than they were when they went in. So the rider program is a middle ground to try to help protect society, but not do more harm than good. And the rider programs are up to the judges. The prosecutor makes the argument to the judge, the defense attorney makes the argument to the judge, and then the judge ultimately decides if they're convinced that a judge has to have an abiding good faith belief that the person will be successful on probation. So if the judge cannot elucidate that, then the judge says, what's the next thing that I should do? And the goal is to do minimally invasive things or the least restrictive things, unless the person is such a risk to society that they just can't be trusted.
So the Idaho Code tells a judge, unless there's a mandatory prison sentence, that a judge has to consider probation first. The legislature has passed a statute, it's been on the books as long as I've been a lawyer. You have to start with probation. We're going to intervene in someone's life and freedom as little as possible, depending on certain other factors. What's the nature of the crime? What's the person's history? Are they amenable to rehabilitation? Do they have mental health issues? Do they have substance abuse issues? There's a lot of things. And so one of the things that is hard for me to sit back and watch on social media is when sometimes the loudest voice gets noticed most. And I I could not even count how many times on social media I've seen somebody post, well, if you get caught with a little bit of weed, you're going to prison, but if you molest a kid, you're going to get a rider. In my experience, that's 100% not true. It's just not accurate what's happening in court. It's just misinformation that people regurgitate, people that don't quite understand how the criminal justice system works, how hard judges work, how hard prosecutors work, how hard public defenders work every day to try to get the right result. Being a judge, I said being a prosecutor is hard. I said being a public defender is hard. Being a judge is hard. They have to balance a lot. And we have a lot of really good judges that take their job very seriously. And I get very disheartened when I see the way that the judiciary is getting attacked. Like I said, on the national level, maybe there's some hacks out there that are political hacks that are just doing what they're doing because of who appointed them. We don't have that here. So I would just encourage people to pay a little bit more close attention, show a little bit of grace to our judges. There's a lot, every case is an individual case. And so when you see a story, well, so-and-so got this sentence instead of this sentence we think, maybe the judge got it wrong. Maybe the system did fail that victim. Maybe not, though. Maybe there's a lot that went into getting to that conclusion. Maybe there was the good prosecutor, the good public defender, the good judge, the good law enforcement officer. And so it's hard to judge the judges on each individual case without knowing everything. Now, there can be broad policies that can shift, and maybe we can say we do need to have, maybe society can vote, or the legislature, or y'all can, vote the representatives in that say we need to stiffen up sentences on certain offenses because we see them happening more, and we think it's in society's best interest to pass this law that says this is what the judge should consider in these cases. Here's your guidelines, judge. There's also things on the other end that maybe we're a little too hard on, and that's where places like this and forums like this and being active and voting comes into play. It's just so complicated when it comes to seeing that. And so there's been hundreds of cases where I walked out and said, wow, my guy got a lenient sentence. There's tons of cases I've walked out and said, I can't believe that's what happened to my client. I've cried after sentences that my clients have gotten that I thought was unfair, too harsh. And there's a whole bunch of sentences where you come out and you say, you know what? It's probably what he deserved. Not what the prosecutor wanted, not what we wanted, but probably what we deserved. And that's most of the cases, right? So a lot of the times what we see are the outliers. And so I think we need to show the judges a little bit of grace. They don't always get it right. I'm not speaking on behalf of the public defenders or state public defenders, speaking on behalf of Jordon Crane, but this is just kind of what I see. And social media can create volume that doesn't really exist. So always make sure to trust but verify when you're seeing these things. Don't get me going.
I understand. And along those kind of lines, we do what's called involuntary commitments as well. So when a person is deemed due to their mental illness that they are not safe to take care of themselves, if they can be a danger to the community or to themselves, or not able to take care of themselves because of a mental illness, and they can be committed to the Department of Health and Welfare, and they can be held, and if the judge finds that they need to be committed, then they can be held at the local BHC, or they can be taken to State Hospital South in Blackfoot or North for treatment and restoration to get to a point where they're stable and they can take care of themselves. And those are, often that you think of like maybe the mentally ill, homeless people that can't take care of themselves, but it's also people sometimes who are developmentally disabled. They have autism or intellectual disability, Down syndrome. Typically, they won't, a lot of times they won't qualify for commitment because maybe they have family, but sometimes they don't have family. And sometimes maybe they are dangerous but they can't take care of themselves. Also, they just passed a year ago one for neurocognitive, where if people have a neurocognitive disorder like Alzheimer's or something like that, they can be committed for a shorter period so that they can be stabilized and get placed somewhere, because they're not mentally ill and they shouldn't be at the state hospital south for mental illness. If they're, in their 80s and they're got Alzheimer's and they don't have any family that can take care of them, they should be, taken care of in a home. Also, child protection. So when health and welfare gets a report that children are being abandoned, neglected, abused, or law enforcement comes into a case where they find children that are being, abandoned, neglected, or abused, or the parents get arrested for something and it leaves, young children at home with nobody to take care of them, health and welfare can take those children, put them in protective custody. And in those cases, historically, the public defender's office would represent those. Those now belong to a separate division, the alternate counsel division with the state public defenders. They have attorneys that just do those things. And that's a civil procedure. It can be unrelated to criminal charges, but it also can be related to criminal charges. And there is a treatment court that is specifically for the child protection, people that have child protection cases.
Are public defenders ever brought in to be consulted maybe by a judge who's looking at a warrant to, I don't know, maybe it's not even required to take children away, I don't know. But do public defenders ever get involved before the kind of, what would you say, impactive act of taking children away?
Okay, so no. There's one case where I can think of where we do. So a public defender is appointed by court order once a person has applied when they've been charged with a crime, okay, or a health and welfare case. Aside from the mental health issue ones where they're seeking to commit them due to their mental health. So we are appointed and we're ordered. So that's the other thing, is we're ordered by a court to represent that person. Then we will represent that person until the judge says otherwise, whether the case is done or whether we're released. So a person who says, I don't want you as my attorney, will tell the judge because I'm ordered to do that. Now, there are times where if the state is seeking to, during an investigation, say into a sex crime or a murder or some super violent offense, and they want to gain the bodily fluids of a person, either by taking their blood or their saliva or swabbing their body for some sort of fluids or DNA, they have to get what's called a body attachment warrant, and that will be signed by a judge, and then we get called to be there to witness, to ensure that that process is done according to a warrant and according to the law. So that's the rare instance where we are involved beforehand. There are times when people are called, the police want to call and question them about something, and the people can say, I don't want to talk to the police officer without an attorney. But until there's a case initiated, the public defenders aren't appointed. And so in that kind of a case, the person should either be quiet and not talk to law enforcement if they don't want to, or they can hire a private counsel and say, I'll talk to you when I have an attorney.
And in the kind of in the child protection realm where you're talking about removing a kid from their parents or in their home, that mainly would happen in a couple of different ways. One, it happens real quick because health and welfare gets a report of something, they show up and they remove the child, or law enforcement comes in and says, wow, this child's in imminent danger, I'm going to remove the child. The other way is sometimes there's an informal case that the family's working with health and welfare, and the family's just not doing it. It gets to the point where they say, we're taking the kids from your custody. We wouldn't be consulted before that. But the law provides for a hearing, I think within 24 to 48 hours, where public defenders would be present, and the state has to come in and show to the judge's satisfaction that there's enough of a concern that the kids can be removed, and the judge can say, no, there's not. The judge can say, okay, yes, but I'm going to put the kids back with the home, but health and welfare can come and check, or they could say we're going to put them in foster care. And then within another 30 days, there's a much more formal hearing that determines whether that should be kind of more permanent going forward, and they initiate an action or whether not. So unfortunately, it's just, like he was saying, that it's just not set up to where we would have the resources or even the notice that because it's happening a lot of times real time. If that makes sense.
There also the public defenders will do appeals. So if you've gone to trial and been convicted, or if you pled guilty and you still could appeal. We handle appeals, and there's also child protection cases can appeal if they're, let's say, they terminated a parent's rights because of the health and welfare situation. The people can appeal those rights, and so that's handled. Some cases are handled by the public defender's office. Others move up the chain to what's called the state appellate public defender's office, and they handle that.
I know everything's on a case-by-case basis, but do you guys have algorithms that you work through on different, like, charges that you'll plea down, or like how many times you've been assigned to the same person over and over again and stuff? Yeah.
I would say no, not in my practice, but it comes along with that experience, right? You're able to look at the case and go, the state has a really crappy case, so they better give us a good deal or we're going to trial. Or you could look at it and go, they've got you, so what are our options? And based on my experience, this is kind of what your options are. What do you want to do? And ultimately, the client has the right to decide whether they want to go to trial or take a deal. So there isn't necessarily like a formula. We get to plug it in and it spits out the result that says, okay, you get probation, you get a rider, it's all really is that case by case. But as you gain experience and as you work with your other attorneys and your mentors, and kind of get a feel a lot of times for, what's really going to happen, what's the right thing, and you kind of build that bank of all these other cases that were similar enough. You can say, hey, this is a lot like this other case, so I think that this is how it's going to play out. But
going back to your guys' Venn diagrams with all the other things that like influence how people become criminals or criminal-minded, like, how do you guys deal with any recidivism after one of your cases where that same person went out and abused another child, or like substance abuse and got a DUI, and all those like things that would keep me up and not let me sleep at night?
Unfortunately, yes. Like you said earlier, in a perfect world, people would do something once and either learn the lesson or correct the behaviors and get the things they need. But unfortunately, no. If a person, we see recidivism a lot, and I wish we knew the numbers, the true numbers. If the person has a drug conviction because they have a substance issue and they go to treatment, they can relapse. And if they relapse on an illegal drug, technically, it's on an illegal drug every time. That's what the judge will say. You're using an illegal drug every time you're continuing to get high. And if they violate probation, then they can come back before the judge, and the judge can decide what to do with them. So that's a recidivism on its own. They can recidivate with new charges. They can get picked up, driving their car or whatever. There's a new waiver that the state has just passed that took effect July 1, where if you're on probation, you've waived all your Fourth Amendment rights. The police and probation officers can stop and ask you to search you if you're on probation, search you at any time without reason. Without any reason, every day they can just do that. And if you're a person who's struggling with substance abuse, at any time you could potentially have something in your pocket, in your house, in your car. So yeah, that does happen. That's where there's evaluative risk tools that they have where they call it like a level services index, and it looks at 8 to 10 categories, which are like criminal history, whether they have accommodations, whether they have financial stability, whether they have substance issues, with their families, and it's this that goes into an algorithm that we don't have access to, and it spits out like a risk level. It's just this number, low, medium, high. That's their risk to recidivate with other crimes, and so that's where they look at: are you a person who could go be on probation, or are you a person that should do a rider, or are you a person that's just so dangerous that you, to yourself or others, that you need to go to prison? And so unfortunately, that's where that recidivism kicks in. And like one of the biggest numbers that can go in that is prior criminal history. Once that's done, that's kind of set. You can address housing, you can address a job, you can get them clean from substances for 2 to 5 years, whatever, but you can't change that big number. And so that always puts kind of like a minimum thing there. So, and I don't know that we have any good numbers for recidivism. I know that Idaho has one of the best treatment court programs in the nation. We just went to some training in Oklahoma City, and quite frankly, Idaho is great. Like compared to some of these other states, we were horrified. But I think our statewide success rate for treatment courts is 60% for at least a year afterwards. But past that, they don't track those numbers. So then we don't really know 10 years later, you know, what's our recidivism rate. We just don't know. And then finally is the Post-Conviction Act. So if a person feels that like they were convicted and they file an appeal and their appeal is not granted, and then they can say, but my attorney didn't do a good job. So an appeal is a legal issue based on factual basis or legal basis. The post-conviction is my attorney didn't do a good job. My attorney was asleep during the trial. He didn't file motions that he should have, whatever, any number of things. And that's a civil case where the client, the defendant, can file essentially a lawsuit saying, I'm suing my attorney, he didn't do his job. And that's what kind of part of that Tucker lawsuit was, as well as people saying that because of my attorney not doing the job, I shouldn't have been convicted. So, you know, the finances and the workload issues all contributed to a system that before the state took over was overburdened on the part of public defenders, was underfunded, and according to the lawsuit, people didn't get fair representation and fair results in trial, at trials or in plea deals or whatever. So the goal is to increase funding, increase the skills and the training, get workloads under control, provide investigative services, social support services, so that people have a fair opportunity to defend their cases. To prevent burnout, because that, quite frankly, is something that has been a problem. And not just with public defenders, but prosecutors statewide and nationwide are struggling to fill the jobs with people in this, especially this avenue of public service. Many other states are struggling with their defense programs. Massachusetts right now is struggling because Massachusetts, which has a far higher rate of cost of living, pays less for their contract attorneys than our state does. And Washington just changed their workload standards to a much better number than we have, and we'll see how sustainable that is. So, they're, you know, nationwide and state over the state, they're struggling to have the number of people doing this, and so, quite frankly, it's expensive.
How does the workload issues for both you guys and the prosecuting office like impact like everyone's right to a fair and speedy trial and that kind of thing? Have we ever like bridged like you're off because we couldn't get to you in time?
We've never been able to say I'm not going to represent that person because we have an order from the judge, and the judge's order doesn't say anything about is this your 211th felony case this year? Because the judge doesn't care. Now, we hopefully are going to get to a point where we have the funding, because we have a law now that says here's the public defender's office and here's what they're going to do and what cases we represent. The workload standard is internal, and that's in play with the executive office determining that number. That's why they're working on the case numbers with the tracking mechanism to determine what a fair number is.
We hope that it hasn't ever led to that. And, you know, I can't say that I've necessarily seen that. Like I said, back when I started, there were 6 attorneys, and we've come a long ways since then. Just to have the 14 here in this county And so we do our best. And that was kind of the basis of the lawsuit is there's a risk because the number's so high versus did it actually happen? And so there's kind of this balance that the court had to do, and the state intervened and said, we'll take it over. And hopefully we can right the ship enough to where at least those concerns no longer exist. But, funds are limited. So.
If I can, you've been talking about the amount of funding that's needed. As a metric, can you tell us where does Idaho place in the amount of incarcerated people as compared to other states in the United States?
Well, according to one of our Idaho Supreme Court justices, we incarcerate more than any other state in the nation.
We're easily the top 5 in the United States as far as the percentage of our population that we put in prison. We're probably the first when it comes to incarcerating women. So I think if you were to look even globally, we're probably leading the world almost in incarcerating women for some reason. We incarcerate women at a higher percentage than almost anywhere on the planet.
I think we've talked about all these issues. This is kind of the conclusion, why we do what we do. I don't want murderers and rapists running around the streets harming me and my family and my neighbors either. But what our job is to ensure that prosecutions are brought with proper facts under the law, under the statute, under the criminal rules and procedures and the rules of evidence, that people's constitutional and statutory rights are upheld, and that it's done properly. And if everything is done right, then a prosecution and a conviction should be justified. And if it's not brought properly, that's our job, is to ensure that is proven wrong. What I say is that they have to do their job, and they don't get to cheat and win.
And I kind of alluded to it earlier in some of my comments about holding the state to the line as far as the Constitution, right? So there's some very important things as a public defender. You have your constitutions and you have your clients, and you got to protect those. But if I'm being honest with you, most of the time, your clients are going to end up convicted, right? Maybe the facts just aren't there, or they did something. And so then, I didn't coin this term. I heard it once. I can't remember where, so I can't necessarily take credit for it. But I heard it referred to as punishment with morality. And so if you step back and think about what happens in a criminal court when someone's getting sentenced, we're saying we're going to take your life, we're going to put shackles on you, and we're going to cage you and take your liberty. Maybe we're just going to fine you and take your money against your will. But those are some really major things. The most intimate contact that any of us could ever have with our government is when they take our life, our children, or our freedom. That's happening in our courtrooms. The government is taking those from our fellow citizens. And so in order for us to have a system where we say we did the right thing, us as a community are going to look at the court system and say, I'm okay with the court taking my fellow citizens' life or their children or their freedom, is because we gave them the opportunity to be heard. We protected their constitutional rights. We followed the rules. We did it morally. We're justified in taking this action against this citizen because we have the moral high ground. When you start cutting those corners, then all of a sudden we start to lose the morality when it comes to handing out that punishment, right? So we want to be able to sit back and go to bed at night and say, you know what? It was the right thing and we did it the right way. Because it's a big deal what happens in our courtrooms. And so it's that punishment with morality, even aside from whether we're going to convict somebody at a trial or win the trial, right? It's those correct outcomes. And us as a society, as the good guys, want to say we had the moral high ground and we did the right thing and we got the right outcome.
Do you happen to know what the major reasons are for women being incarcerated at such a high rate?
I wish I knew. It's kind of shocking to hear that, right? And I don't really know what the cause of that is.
A higher percentage of them than not is related to substance abuse. And there's a lot of trauma and violence that happens that leads to that. And almost every person that has a substance abuse problem has a significant amount of trauma in their youth. And that's something that they've started focusing on the past several years in the treatment courts and things, is trying to address that. And it's easy to say, well, I had trauma. You know, I was grounded, I was spanked, or something like that. We're talking more significant than that. We have. This isn't all. And all of these issues interplay in other ways. I could only put this many things on there, but there's more that go into this. And so all of those interplay and create, nurture versus nature, right? People can be created through the things that they are exposed to. And different people respond different ways. Some people thrive and some people don't. And we're open to questions. Mr. Network Fellow, do we have any online questions? Okay.
No, we actually don't let online
Oh, don't we? Okay.
ask questions, and that's because if they want to ask questions, they need to be here. So,
Okay.
because you need to actually see who's asking the question,
Understand.
and we firmly believe in that. So, does anybody else have any questions? Yes.
Looking at the women that have been convicted for the same crime, are they getting similar, like, sentences to men or less, or how do we rate with that?
I would say they're consistent with what men get punished with. I don't think I've seen women treated less harshly than men. But in general, women don't seem to have as high a criminal capacity or history. I see men with, more extensive criminal history than I see women in general.
And also, our experience is kind of limited to our area, and so it might not be our area particularly that is influencing those numbers when it comes statewide. But that's just one of those, studies that you come across in our line of work that kind of makes you sit back and go, wow.
Do the district attorneys have any role in training or providing any kind of constitutional training to police departments so that maybe things that could be avoided or should be avoided are?
As a public defender, when we kick their butt in court, maybe they get some training. No, I'm just kidding. That's kind of one of the things Jason said. There's a little bit of a partnership, but we don't necessarily kind of veer over into the training of law enforcement. They probably have their own counsel that trains them, I would assume, without knowing, that the prosecuting attorney would be the one that would say, all right, law enforcement, here's where the line is, here's what constitutional rights are. I know Sheriff Hulse values constitutional rights, and so he takes those seriously. I'm not sure what kind of training they would get. They probably receive some in their post academy, but we usually just train them in court.
Essentially, we are training police officers by pointing out what they didn't do right. And so in a perfect world, it would happen one time, right? They would do it, and then they would learn, and then it wouldn't happen again. And that, it's not saying we're teachers, but essentially what we're doing is we're training them. You did, when you asked the question, you said the DA. And so that kind of means the district attorney or the prosecuting attorney. The prosecuting attorney, in our eyes, and functionally, is supposed to be a independent review of what the police did. Because the prosecutor should take the police report and say, as a prosecutor, do I think this meets the law? And is it a proper constitutional and procedural legal arrest? And so in our realm, that's where we would say that the prosecutor should be doing that first before it ever gets to us. And to some levels, sometimes that happens, sometimes it doesn't. And that's where we come in to then press the issue.
Have police body cams made your guys' job easier or more so for the prosecution? Or does it depend case by case?
It's made our job easier and harder. So it's easier because one of the nice things about video most of the time is it is what it is. For the prosecutor, for the law enforcement, for us, right? For the most part. And so it's nice to have that because it helps get those right results, because it's, not based on just memory or biased viewpoints or that kind of thing. What makes it difficult is we now have hours upon hours of video. We'll get one relatively simple felony, for example, or even misdemeanors, and there could be dash cam for hours, there could be body cam for hours, there could be multiple body cams, and we're kind of tasked with watching it, because what if there's that little thing that happened, or Sally said something at this point, and so we can't just take it for granted. So it's good in that sometimes it makes the facts more factual, if that makes sense, but it sure has added a lot of work. And cell phones and all the cell phone dumps and messages, and it's just, there's a lot to sift through when we get a case.
Historically, before we had cell phones and things and cameras like that, it would be an officer said this happened or a witness said this happened, and then it comes down to do the people believe it? I remember the old my cousin Vinny, the little old lady with the glasses, can you please take your glasses off, right? But nowadays, people are used to seeing cell phones everywhere. They're used to seeing body cams on police officers. There's cameras on light poles. There's cameras outside of Maverick gas station. There's cameras on outside of people's houses or your doorbell, and those will get collected in cases. And so not just body cams, but we'll have sometimes dozens of hours, and in sometimes that solidifies what the case is, either good or bad. Quite frankly, doesn't often help our clients more than it hurts them, but it does provide the evidence and it provides the story. And we went to trial a lot in the last year, and the jury people, they want to know a story, they want to see what happened, and they want to see the evidence, and they want to see video. And in these days, they expect the police officers will have body cams. And the majority of Idaho Falls Police Department officers and Bonneville County sheriffs, they have body cams. I'm not sure that all of them do, but most of them do. Idaho State police officers do not. They have a dash cam, and they try to pull up so that you can see what happens, but you don't. Like sometimes you'll see the things where something goes off to the side of the thing. You can't always see that, but they have their lapel mics keyed up so you can at least hear. But that doesn't get the people, because a police officer's body cam's about right here, so you see what his chest sees, but you don't see him turn his head. So when you'll get a body cam of a police officer says, I walked up and I looked in their car and I could see drugs in plain sight. Well, that body cam might very well see that. Might not, So it's just, and that's a level of detail that never existed before a few years ago.
You've seen videos of people that don't let the police get the Miranda rights out and stuff. Like if they don't say the whole thing exactly verbatim, does that throw things out? Or I made an attempt and they were being belligerent or didn't understand it because they were having a mental health episode?
Well, it depends. Miranda only really provides that anything you say after that can potentially, waives your right to remain silent. If they Mirandize you and tell you what your rights are and you keep talking, then they might be able to use those statements against you. If you're not Mirandized, you might have a way to keep statements out. So if you're not going to stop for the police, you might have waived that right.
So when we talk about Miranda, if you go clear back, right, what Miranda is we have the right to remain silent. We don't have to answer questions to law enforcement. Well, law enforcement had a lot of tricks in their bag to convince people to give up that right and to talk. And it wasn't necessarily that they were beating them with the rubber hose, but they would use psychological tricks. It's called the Reed technique, is one of the ways they would do it. And it's a psychological way to manipulate people into telling you what you want them to tell you. And so in Miranda, the U.S. Supreme Court said, when somebody is taken into custody by law enforcement, that environment, that interrogation environment, is inherently coercive. So we're going to require law enforcement to make sure that they warn these citizens that they have the right to remain silent, that anything they say can be used against them, it will be used against them, they have the right to an attorney, all those kind of things that we hear, in order for the person to be notified. And the thinking is that lessens the inherent coercive nature of the interrogation. Does it really? I don't know, right? In your scenario, where if I'm blurting things out, I'm blurting things out. Miranda only applies when we're in custody, we're detained and not free to go, and law enforcement elicits a response from us. So if I'm getting arrested and I'm just blurting stuff out, I blurted out at my own risk, right? The law enforcement didn't coerce it out of me. So that's kind of, if it doesn't come out and you're just blurting things out, they're going to use it against you. Does that make sense? And so a lot of times people think, hey, they didn't Mirandize me, so get out of jail free card, right? Well, that only applies to those statements while you're in custody that were elicited by law enforcement. So that's actually a question we get from clients a lot of the times. Hey, I wasn't Mirandized, so I'm getting out. Nope, you're not. They caught you with the stuff, so.
And one of the things is that's telling people what their rights are, at least advising them. You don't learn about those things until like high school government, right? Senior year. So if people didn't finish high school, maybe they didn't get that education. If they didn't pay attention, they sloughed through the class, they may not have paid attention. There's a lot of people that think, I know my rights, and they really don't know their rights, you know.
And
so.
And having the right to remain silent and knowing how to exercise the right to remain silent are two very, very different things.
You have the right to remain
Very
silent,
good.
but maybe not the ability, right? Yeah. So, unfortunately. Yeah, so.
Very good. Oh, another question.
So as we discussed a little before the meeting, I recently sat on a jury, and I was surprised. It wasn't a complicated case, but I was surprised as an impartial juror, and tried really, really hard to be impartial. I had to work extra hard to grant the defendant the presumption of innocence that the Constitution guarantees us. My question is that just me, or is that something that you think people struggle with our system?
Well, first off, thank you for serving on a jury. It's probably something we'll never get to do because we're lawyers, and so we would automatically get kicked off. But yeah, I think the presumption of innocence, I think it's difficult, at least in my experience, because we kind of as human beings want to say, okay, it's even, right? We start 0-0. Who's going to convince me? That's a lot of times how we do things, right? Who's going to convince me? You make your argument, and you convince me. So it's kind of hard to step out of that box and realize that as the defendant, you start off winning. You've already won the minute you sit down in the courtroom because you're presumed innocent, and the state has to build that case. And that's hard to communicate to people. I still, it's just one of those things that as an attorney you practice on getting better at, and it's just difficult. But it's good to hear that the jury was back there and keeping it in the front of their mind. I've got to give the benefit of the doubt, you know.
When a person is charged with a crime, that the police have to have probable cause, which means more probable than not. So in a number wise, that means 51%. So that person is 51% likely that they committed a crime. So when they're going into trial, well, they're presumed innocent, but the burden of proof is only 51%. And beyond a reasonable doubt is hard to quantify, because what is reasonable, and what is reasonable between 2 or 12 people for a felony jury is significantly different. Because I don't think it's very reasonable to jump out of an airplane with a parachute for fun, right? There's a lot of people that think that that's great. See, so, average minds can disagree on what reasonable is. Justice Blackstone was a English judge back in the 1500s, and he wrote this Black's Law Dictionary that's about this thick, and they still refer to that today. It's like every judge has that on in their chambers and things, and he had these extensive legal theories that people still refer to, and his theory was it is better that 10 guilty men go free than one innocent suffer. So if you do that math, you're like, okay, that means beyond a reasonable doubt it's got to be something like 91%. And so it's a really high burden, but yet he had to do something wrong because he's sitting here going to trial. That's what people say, and they want to hear from the defendant why he didn't do it or why he's not guilty. But you have a Fifth Amendment right back to 1791 not to incriminate yourself and not to testify against yourself. That currently juries think, well, they didn't say they didn't do it, so he must have done it. And that is extremely difficult for an innocent person to get over. Because a person get on the stand, and an attorney that's wily and knows what he's talking about can twist up any witness, whether it's a defense attorney with a victim or with a witness who wasn't wearing her thick glasses, or whether it's a defendant who's trying to explain what he did and the prosecutor is trying to get him to admit, yeah, you did this. And so it's an extremely difficult thing to get over these days, because especially with social media, there's a rush to judgment. As soon as somebody is arrested, they're guilty. No more writers. Go to prison. You're a bad person. And at the time a person's arrested, they are not guilty. And people have to understand that. A person is not guilty until a jury says so or a judge says so.
Any other questions? Well, let's give these guys a great hand. I mean, this was actually very informative, very, very much. I really appreciated it.
Thank you for giving us this opportunity, Doug.
Oh, I mean, it really was. And I do, we have a lot of things happen here at Stand Up for Idaho that actually led us to this, in fact. And I think this was very excellent. And I do appreciate you coming and doing that. And I'm sure that we'll have a lot more people viewing, and hopefully maybe we'll have you come again, because like I say, I had no clue. Just to be honest with you, I had no clue. I never had to use you or anything like this, and I tried to stay out of that system, but it was very nice to actually understand, and I'd like to say thank you for the passion that I actually felt from both of you for your jobs and all that, and I feel that it's we're blessed to actually have you doing what you're doing right now. And so with that, let's give them another big hand, and thank you so much. And so I'm going to let you go, but remember, I'm going to make a pitch ad. If you want to take a shot at the flag, I'd really appreciate it. It's $20 for the raffle. We do that next. And Stand Up for Idaho, and you guys made a comment right at the beginning. We don't always do things politically. Okay, but I will say this, that politics does affect your life every day. And so it's important for us to pay attention to politics, but there's a lot more going on in the world besides politics, and we need to understand those and be aware of that. And so just keep an eye on this. Next week, definitely going to be into politics, okay? And again, this is the candidates for Idaho City Council, seats 4, 6, and 2 from seat 2. And those people, just by the way, and they've all been invited to come. Now, all of them have not confirmed they will be here. Okay, and they have their own reasons and whatnot, and some of them just don't like having you ask them the questions. I'll just say it that. Anyway, seat 4, the candidates are Jared Dominic and Jim Francis. For seat, seat 6, it's Jim Freeman and James Skinner. And then the two that, now in seat 2, there are actually 7 candidates. And we had 5 of them last week, and I would encourage you to just go look on our Rumble channel and check them out and see how they did. The other 2 that couldn't make it last week are hopefully will be here next week, and that's Brandon Lee and Stephanie Taylor Thompson. So it should be good. And again, if you live in the city of Idaho Falls, they will impact you. And I'll say this is if you are supporters of any of those candidates, I would encourage you to come here, be here with them, because it does make a difference when you're sitting up here and you can see some allies out there and whatnot, because guaranteed the other side is going to have some allies. And so I'd really appreciate everybody to do that. And also, take a flyer back there. Ben Geeson, made up some flyers. This is something that we really all ought to know about. You can say it's political, but it's not really not. It's the Federal Reserve, the national debt. And he started out telling me, how does a penny get into circulation, I guess, currency, right? How does that happen? And if we were to all know that, and that actually, and I'm going to get out, I was speaking out of school, that's how debt's created, a lot of stuff, okay? If we all understood these things, and I mean we all understood these things, life would probably be better for all of us. And so with that, thank you all. Thank you very, very much, and we'll see you next week. Take care.